Hi everyone, and you're welcome to today's episode of Your Lawyer's Corner with Mo. On today's episode, I'll be reading from my book, My Lawyer's Handbook. I'll be reading from chapter 3, page 17, Joint Ownership of Property under Nigerian Law, and the legal implication of joint ownership of property. What is joint ownership? As written here. Joint ownership of property is a situation whereby there are two or more persons who contribute resources to purchase and own title to a landed property, either for residential or commercial purposes. Where there is joint ownership, it means that each party has an equal proprietary right of ownership on the property, notwithstanding the weight of contribution made by each party, and can jointly exercise such rights in respect of the property. The legal implication of joint ownership of property. Where one party dies, the property is owned by the remaining owners. The consequence of this is that the rights in the property cannot pass to the children survived or beneficiaries of the deceased party. So it means that if two persons owns a property jointly under the joint ownership of property now, and one party dies, what it means is that the beneficiary of the deceased person cannot inherit the part that belongs to their person from that property. That's one of the implications of joint ownership of property. Now, there is a unity of possession, title and interest in the property. This simply means that the joint owner can enjoy the use of the property together at the same time. Hence, no party can lay claims of ownership of a part of the property to the exclusion of other parties. Before the rights in a joint property can be alienated to another, the consent of all joint owners must be obtained. That is, if, for example, I want to sell the part that belongs to me, maybe I and another person owns a property jointly, and I want to sell the part that belongs to me, I will have to seek for the consent of all the other parties involved before I can sell my own part. So I cannot just go ahead and say, maybe that part is my own. After all, I can do with it however I want. No, it is not done that way. I will have to seek the consent of the other parties involved. Where consent is not obtained, the title will not be valid. Joint ownership of property can give rise to disputes that may lead to litigation if not properly managed. To avoid disputes, however, a joint property owned by two or more parties can be severed, separated, or properly managed if the parties take steps to sever the joint ownership by way of partitioning upon acquisition of the property. Parties can agree to the partitioning of the property by engaging the service of a lawyer to execute a deed of partitioning with agreed limits, sharing the property between the joint owners to convert it to individual ownership of the land. Where partitioning of the property will not be feasible, then the terms for management, sharing, and final sale of the property be documented by a lawyer to avoid dispute. Where this is the arising situation, the lawyer can include in the management agreement a clause that will enable the beneficiaries or survivors of a deceased joint owner to acquire the property rights of the owner upon his death. I hope you have gotten value from the reading episode of Your Lawyer's Corner with Mo today. Before I go, I would like to remind you, don't just get mad, get a lawyer. Do have a lovely day. Bye.